So hello everybody and welcome to today's CPD webinar brought to you from the Recover Compensate Network. I am Rosie Brown and I'm the Recover Membership Manager, and today I am pleased to be joined by Digby Brown's professional support partner, Catherine Hart, and she is going to be leading our discussion on building better client relations through complaint handling. I am going to be passing over to Catherine in just a second, but I'll do a little bit of housekeeping on my end. So today's webinar will finish at approximately 2 p.m. and we will end with a short Q&A session. If you do have any questions throughout, please put these into either the Q&A or the chat box, which you'll see at the bottom of your screen. There's a little notification in there right now with a welcome message. We will collate these and go through them at the end with Catherine after our discussion. This webinar will also be recorded, so if you would like a copy of that, I can give out the contact details on how to get that at the end of today. That is everything from me. I will now pass over to Catherine to get started on today's session. So thank you very much.
Thank you, Rosie, and thank you to everybody for joining us today. I appreciate that complaint handling is not anybody's favourite subject, but on the plus side, you can count this as your hours mandatory risk management CPD, and as we're coming to the end of the CPD year, maybe that helps to make the topic under discussion a little bit more palatable. So yes, as Rosie said, I'm a partner and head of our professional support team at Digby Brown. You may wonder what qualifies me to talk about complaint handling, so I thought I'd say a little bit about my experience, which hopefully will explain why I have a particular interest in this area. So I've not always been in professional support. I was a fee earner for about 15 years, and a couple of the roles I had involved working for practices that were on the panel for the Royal and Sun Alliance master policy. So that meant that when solicitors were accused of negligence, their files would be passed to us to deal with. So I had a lot of experience of looking at claims against solicitors and reviewing their files and looking at the defence of the claim. I also taught for a number of years on the professional practice course at the diploma at Glasgow University, and I'm the external examiner on the professional practice course at Edinburgh University for the diploma. I am a vice chair of the Scottish Solicitors Discipline Tribunal, which means that I chair some of the hearings that we have, and was a member before that. So that's given me a lot of insight into the type of complaints which arise or can arise in practice. And finally, on an ad hoc basis, I help our client relations manager deal with complaints at Digby Brown, including helping compile the annual complaints report. So again, that gives me quite a lot of insight into the areas where clients most commonly find cause for complaint. So hopefully that sets some context, and we can now go on to talk about how we build those better relationships with our effective handling of complaints. So we're going to look at a number of things. I've just given a list there of the things we'll look at. We'll have a quick look at some common causes of complaints, because I think that's always useful to see a bit of context and where complaints often arise. We'll then look at some of the basics of complaint handling and what we're supposed to have in place. We'll move on to look at some best practice tips and hints in complaint handling. And finally, we'll look at some basic ways to avoid or minimise the risk of complaints. So the first question I think it's important for us all to consider is why is effective complaint handling important? Why do we have to deal with these complaints, which most of us will face at some stage in our career, in an effective manner? And there, I think, are a number of reasons why it's important that we do that. The first is kind of fundamental, which is the reputation of our business. We want our business to have a positive reputation, and lots of client complaints doesn't help to support that. Clients now can be very vocal on lots of platforms. Social media allows that. And so a client who's unhappy can spread the word about that, whether they have grounds for doing so or not. which is something we have to put up with nowadays, don't we? That there are platforms for people to make their feelings known. There's also the loss of business, which is very important if it's a long-standing client who brings you a lot of work, and then they're unhappy and they leave us. And that can make the difference between the business, doing well and maybe struggling. There's also the time involved, and I don't think we should underestimate that, the time involved in dealing with complaints. Any complaint, whether there's grounds for it or not, is time consuming to have to deal with, and particularly if it goes into the formal complaints process, that then becomes something which can go on for many months and involve a lot of time that could be better spent dealing with matters for clients and progressing matters and raising those all-important fees. I read somewhere that it takes 7 times the amount of effort to gain a new client than it does to keep an existing client. And so I thought that was an interesting way of looking at it as well. The extra effort in bringing new clients in is something which we're always working on, but obviously if we can avoid losing our existing clients, that's positive too. So in essence, it's very much about effective risk management when we're dealing with complaints. I think it's an unfortunate truth of the business that we're in. We're providing a service, and so complaints are a natural, if unwelcome, part of that. And so I think if we think about it that way, that there will be complaints arising during the course of anyone's career, it makes it slightly more palatable, albeit often they're groundless, and that can be extremely frustrating. So we'll move on and look at some of the common causes of complaints, just to set a little bit of context. And I've got some useful information over the years from the SLCC. You'll know that the Scottish Legal Complaints Commission is the gateway for all complaints. So it doesn't matter if it's a complaint about service or it's a complaint about the conduct of a solicitor, that all those complaints will go in the first instance to the Scottish Legal Complaints Commission. And I should also mention they also deal with complaints against advocates as well. So it's an all-encompassing gateway for complaints. And they are good at publishing an annual report, and that gives us some helpful statistics about practice areas where complaints arise and the basis for complaints. The most recent report was to, I think it was the end of June 2022. So for the year preceding that, there were 496 complaints taken on to the investigation stage. So that means that the complaint got through the stage of finding out whether it was one that could proceed or not. It wasn't time barred, for example, and went through the stage of seeing if they could assist the solicitor and the complainer to reach an agreement or a compromise, and that wasn't successful. So the investigation stage was reached in 496 of the, I think it was 1,158 complaints that were closed, and complaints received in that year was 1,159. So well over half of them didn't proceed to the investigation stage. And I also think if you think about the numbers of solicitors in Scotland, I think we number around 13,000. And we also think about the fact that complaints against advocates also go through the SLCC, 496 going on to the investigation stage, doesn't seem such a large number in the round. I thought it would be interesting to ask your opinion on what you think the most common area of practice in which complaints commonly arise would be. And I've given you three options there, and we've, by the magic of technology, we've managed to have a poll. So if you wouldn't mind completing that and letting me know when you think, which area you think would be the one where complaints would most commonly arise. So we've got lots of answers coming in, which is great. So I think we'll maybe close the poll at that point and we can share the results with you. So yes, we find that residential conveyancing has got the most votes with 76%, family law 24%, and mergers and acquisitions no votes at all. So I don't know what that says about mergers and acquisitions, but if I share the next slide with you, after we've had the poll, oh, I think we have to have the poll finished then. I don't know if I have to click on share results, Rosie, do I?
Sorry, Catherine, that should be the result sharing, and stop sharing now.
Right, thank you.
No worries.
No problem, I'm still seeing it on the screen. That was the only thing, just it's not allowing me to move my slides on.
All right, 1 second, let's see if it's possible for us to do it on our end. It seems that the poll has stopped sharing.
Oh, it's odd, isn't it?
Could you press exit at the top of the screen for your poll, Catherine? And I think maybe that'll allow you to move on.
If I just close it, wonderful. Thank you
There
very much.
No problem.
Thank you, Rosie. Apologies, everybody. The wonders of technology, they're wonderful. It's just me. It's human error there. So let's have a look at what the findings were. Oh, for some reason my slides aren't moving on. That's very odd, isn't it? Wonder what. Oh, here we go. Just being impatient. So the Legal Complaints Commission report for the year to 22 gives us this information, which is really reflective of the voting in the poll. So residential conveyancing is the area which has the largest number of complaints. I didn't give you the option of wills, trusts and executories. I thought I'd throw in a curveball, but that's comes in second, and then family law third. Litigation, and then just general personal conduct of the solicitor coming in after that. And those of you who are good at addition will see that doesn't come to 100%, but the rest were a mixed bag, if we could put it that way, so couldn't be so easily categorised. But I think that it's quite interesting. For me, what that says is that the complaints tend to arise in areas where individuals are instructing solicitors, and also where there is an element of stress and pressure involved for the solicitor, for the individual concerned. Moving house, well, that's known to be a very stressful event in one's life, and then executories tend to arise, when there's been a death in the family, so that's a stressful event, and so on. So I think that's quite helpful to look at the types of areas where complaints arise, perhaps not very encouraging for those who practice in those areas, but at least that there is a pattern there, and it tends to be the sort of matter where we have individuals as clients, rather than it being something of a corporate nature, for example. And that's very much reflected over the previous results of the SLCC annual reports as well, that larger scale commercial corporate matters don't tend to give rise to anything like the number of complaints that we will see in more personal types of law, as it were. So buoyed by the success of my first poll, we'll have another one, and this time I'll hopefully get it right when I come to close it. So the second thing I wanted to ask you was, what do you think is the most common cause of complaint? So the basis on which people are complaining against solicitors. And again, we're getting lots of votes in, so take a moment to look through those. So I think we could maybe share our results, Rosie. So we see there that communication is getting the highest vote, followed by delay and then failure to act in the client's best interests. So we'll find out if that's reflected in what the findings were of the SLCC. Just give my slides a moment to catch up. So absolutely right, communication, almost a quarter of the number of complaints received relate to communication. And I'm going to go on a little bit later to speak about that briefly. Sometimes I think that should say effective communication rather than communication, but whether the communication is effective or not tends to be the problem, as opposed to there being a complete lack of communication, which is something rather different. We also then have failure to act in the best interest of the client. And interestingly, that came out third in the poll, but that's actually the second highest basis of complaint. Lack of or accusations of lack of personal trust and integrity come after that, and then delay, relatively low at 8%, which is interesting because delay, I think, is something which clients often perceive is occurring in their matters when actually we know that things are taking the time that they tend to take. And then the 8% as well, we've got failure to advise adequately. So again, I find these figures and this a useful insight into the types of areas that give clients cause for complaint. And in knowing that, I think it helps to inform practice, or should help to inform our practice in terms of the way that we interact with clients. If we know that communication is an area where clients find cause to complain the most, then that gives us something to think about in terms of our own communication. So wanted to look at just the basics of complaint handling. This won't be news to anyone, I'm sure, but sometimes it can help just to go over the very basic requirements, and hopefully we all roll our sleeves up to deal with our complaints rather than hide our heads in the sand. Although I'm sure there's a combination of both approaches, which is what most of us would be like, I'm quite sure. So you'll know that there are specific regulatory requirements in relation to complaint handling, and we are actually covered by a rule in this case, Rule B5, which indicates that a practice has to have a client relations manager, so a named person who deals with complaints. We have to have a written complaints procedure. And we also have a requirement to produce, if asked to, a written complaints record. I mentioned there's a template available on the Law Society website, and something that I'm going to do at the end of the session is provide Rosie with some links to useful resources, so that that will come out with the recording for you. Because rather than having to try and remember all these things or look for them, we'll provide the links. But there's a useful template which obviously sets out what the Law Society expect you to have in the complaints record. That should be a written record which we keep up to date. And as I say, the Law Society actually have the power to ask to see the complaints record. And I think it's a period of 21 days in which that's to be provided. So it's something which it's a good idea to keep up to date, if at all possible, rather than being asked to provide it and having to sort of think back and fill it in retrospectively. The Law Society recommend, as do the Commission, a first tier resolution of complaints, they call it, which basically means they actively encourage us as solicitors and our practices to try and resolve complaints without them having to go any further. And I'm quite sure that's all what we all try to do, endeavour to resolve complaints ourselves without allowing it to become part of the more formal complaints process. But that's not always possible, no matter how reasonably we approach things. And also I wanted to mention consideration of third-party complaints. I'm sure you all be aware that last year there was a decision of the Court of Session in a case where there'd been a third-party complaint against a practice, and the practice questioned whether they should have to provide their file to the regulator. And the reason for that was both client confidentiality, but also legal professional privilege. And the position was taken that this file is for the client. And so if a third party has made a complaint and said that they've been directly affected by the service we've given to our client, then we would need our client's consent to waive privilege. The court agreed with that, and so that's something to bear in mind if you are dealing with a third-party complaint. I'm sure you're aware that it's not just clients who can complain about us, but third-party complaints have to be by someone who is actually affected by the service that you've been giving to your client. So your client might be quite happy with the service, but the person who's complaining may not be. However, it's for you to decide whether you want to pass over your file to the Complaints Commission, and that would involve having to seek a formal waiver from your client of privilege. So just something to bear in mind. So I think it's also useful to look at what is a complaint. And the 2007 Act defines a complaint as any expression of dissatisfaction, which almost makes me smile, but in a sort of depressed way, because I mean, any expression of dissatisfaction is pretty wide, isn't it? And some of us might say we hear expressions of dissatisfaction on a regular basis. However, I think it's good to maybe delve into what's said to you a little bit more deeply and ask yourself, actually, is what being expressed more of a concern? So it's not a dissatisfaction, it's just a concern that the client has, which is being expressed in that way, but actually I can deal with it by addressing the concern. Or is it really a query, an inquiry, but dressed up as an expression of dissatisfaction? Maybe that comes of a feeling of frustration on the part of the client. So delving into what's been said a little bit more deeply and finding out whether actually it's not a complaint at all, it's more just somebody wanting clarification or wanting to have you allay some of their concerns. And those aren't complaints and shouldn't be dealt with as such, although obviously you don't want to ignore that sort of thing. But if you're satisfied that it is a complaint that you're dealing with, the SLCC have statutory guidance. So there's guidance on how to deal with complaints effectively, which I'm going to go through because I think that's helpful to have that information. And they also have some useful general advice. And again, these, although I've put the links in the slides, we'll circulate them in an email because that's an easier way for you to access these things. But the general advice is on the topics which I've noted there, and there are particular practice areas, only 3 at the moment, but nevertheless there are practice areas in which the Commission have looked at the sort of complaints that commonly arise in those areas and put together guidance which is bespoke for those practice areas. You may know that if a complaint is brought and is ultimately upheld, then there's a complaints levy of, I think it's £5,000, which has to be paid, which is clearly a frustrating outcome for people. But one thing I would mention is that if you can satisfy the Commission that you have followed their statutory guidance and you have effectively used best practice in complaint handling, there is a prospect of having the levy reduced. And I think it's reduced, I don't know if it's on a scale down to £3,000 or just to £3,000, but you know, there's a possibility of the levy at least being eaten into a little bit if you can show that you have handled the complaint in accordance with the statutory guidance and your own complaints handling policy. So again, something that's useful to bear in mind. So I'm going to touch on best practice in complaint handling, and this comes from the statutory guidance. And I think it's useful just to look at what the guidance is telling us should be in our complaint handling procedures, so that we can attempt to set up what is considered best practice. So my final poll, some of you may be glad to know, but Can I ask just at the outset, how effective do you think your current complaints procedure is? Do you think it's highly effective and it complies with the requirements? Is it somewhat effective, or are you, to be honest, not sure? So lots of, I was going to say lots of people still voting, but I think that's us maybe got to the end of the voting. So that's interesting. So 40% think somewhat effective. And I would say that's absolutely in line with what most people would say. Things can always be improved, but I'm really pleased to see about a third of you think your policy is your procedure is highly effective, and that's excellent. It's clearly been given lots of thought, and some people aren't sure. And I think again that's it's good to be able to identify that, isn't it? Because it then gives you an opportunity to maybe look at it and measure it against what we're going to talk about and see how it comes out. So I will close that. I'm now getting very adept at this. So we'll move on. Just have to give it a minute to catch up. Just click on it again. There we go. So the guidance, the statutory guidance talks about 6 aspects of the complaint process or complaints procedure that we should be looking at to make sure that it fits in with those. And I was going to just touch on those so that we have an idea of what they all mean. So our policy or our complaints procedure should be accessible. And by that, they mean it should be available for those who work with us. So anybody who might receive a complaint, it might be your receptionist, for example, is the first port of call for these things. Would that person know where to find the complaints handling policy for the business if required? So is it accessible to our business, our colleagues, but also is it accessible to clients or anybody else who wants to complain? Is it perhaps on the website? Is it in the terms of business? And the terms of business, which we'll look at as well briefly, should have information about the complaints process and how to go about making a complaint if somebody wishes to do that. It should be user focused, and by that we are told that it should have in mind the person wanting to make the complaint, which might sound slightly counterintuitive and contrary to our own interests. However, really what that means is that anyone who wants to complain should be able to do that. The process should be clear and transparent. It shouldn't be difficult for somebody to find out how to make a complaint, who should they contact, and what should follow after that. What's the process? If possible, it should be set out in a way that users find accessible and they can follow, and also that's neutral, so that it's not focused on blame. It's simply focused on trying to investigate what the complaint is and finding a resolution for it if possible. It should be timely, so that just means that when a complaint's received, it should be dealt with as soon as you're able to do so, even if that just means acknowledging the complaint, so acknowledging that the complaint has been received and then indicating that there will be some time needed to investigate the complaint and how long that will be. 28 days seems to be the sort of time scale that's suggested as being an appropriate time to say to whoever's complaining, I'm going to take 28 days to investigate this and look into it, and then I'll get back to you with my findings. But it may well be that you need more time. Perhaps you need to speak to a number of colleagues, do a bit more investigating. And so the idea is that you would get back to the person complaining and let them know that. So if you need more time, that's not a problem, but just allowing them to be aware of that. Objective means that it's hopefully not about apportioning blame in the sense of saying who's right and who's wrong, but it's a fact-finding exercise. It's about finding out what the nature of the complaint is, and then looking into that. And I think that's really quite an important element of it. What is the nature of the complaint, and what is it that the person complaining about is saying, and amongst everything that they're maybe passing on to you in terms of their dissatisfaction. So it's trying to find out what the complaint is and what's behind that. Then it'll be resolution focused, hopefully. So looking at ways that the complaint can be resolved. Not every complaint can end up with the person complaining being happy with the outcome. That's unrealistic. But if at least the process is driving towards finding a resolution that is at least satisfactory for both sides, then that's an effective process. It doesn't mean, as I say, that it has to end in a resolution that the client or whoever is complaining is happy with, but at least if that's the focus of the process, then that's the main thing. And finally, the process should be a tool for learning and improvement, as it says there. So really, I suppose that's a bit about reflecting on the complaints that are received and seeing, for example, if there's a pattern to them. Is there some area of practice which you maybe need to change because it's giving pause for complaint? I know that we will look at our complaints record and see if there's a pattern. There's some, for example, types of work that would just give rise to more complaints than others. It doesn't mean the complaints are justified, but that's something that the business can then be aware of and can inform the handling of complaints. So I suppose it's about, rather than just keeping a note of the complaints you've had and filing it away in the drawer you don't open, it's actually looking at it and thinking, well, what can we learn from this? What can we change which would help in dealing with complaints effectively? So the process, I suppose, can be split into three different stages. There's the engaging with the person complaining, which may feel like a bit of a mountain to climb, might not be particularly what you want to do, but in terms of effective complaint handling, it's vital. So it's vital to have the conversation or to exchange emails or engage in whatever way works best to find out the basis of the complaint. And as I mentioned before, I think that's really important because it may well be in exploring what actually is the person complaining about. You can distill it into a particular thing. So it's that they feel things are taking too long, or they feel that I've not been in touch with them enough. But that might come out as a rant, a lengthy email with lots of points which the client wishes to make. But at the end of the day, it's distilled down into, I just don't feel that you're communicating with me well enough. Our practice is always to have that initial engagement and then set out in a letter what we have taken from the conversation to be the nature of the complaint. And I think that works quite well, because then when you do the investigation and the ultimate provide the ultimate findings, you're referring back to your complaint was about delay, or your complaint was about the fact that you didn't have your phone calls returned within 3 hours or whatever it is, so that everybody's clear about, well, this is the complaint I'm investigating. And then the goalposts hopefully can't change quite so easily with the client saying, yes, okay, well, I accept what you're saying about that, but actually I'm also unhappy about this. So engage, find out the basis of the complaint, if indeed it is a complaint. So remembering that it might just be a concern, for example. Then to explain the process, so what's going to happen next. I'm going to investigate your complaint. I'm going to look into it. I'm going to speak to anyone involved and review the file, whatever the process is. Explain what it's going to be, explain what will happen then, which is that I will respond to your complaint, and I will give you, ideally, a full explanation of why I've reached the opinion or the view that I have. And I think that's important too, because simply saying to somebody, I've looked into your complaint and I think it's groundless, is not really going to help necessarily resolve matters. But if you say, I think it's groundless for the, or I find don't uphold it for the following reasons, then that's far easier, I would say, to justify. It doesn't mean that the person's going to be happy with it, but at least you're able to justify the findings that you have reached. I know that some people who are maybe in practice on their own or in a smaller practice will be challenged by the fact that they have complaints, because frankly they're often dealing with complaints about their own practice, their own matters. And some of the suggestions that I've seen made are engaging with the local faculty to see if there's anyone who may act as client relations manager for you in a particular situation. So review the file and give an impartial view, and that feeds into the objectivity of the process. I know that some people have a buddy system set up where they look at complaints that their buddy receives and vice versa, and it gives that that objectivity and just that distance, because none of us likes to be complained about, and if it's something we've dealt with, then it's very difficult to be entirely objective about it. And I would imagine for the person complaining, it's difficult for them to think that it's been dealt with in a very objective way. So finally, I wanted to touch on a few areas that we can look at to try and avoid or minimise complaints. As I say, it's part of our job, isn't it? Unfortunately, we're dealing with individuals, and often in stressful situations. We provide a service and people will complain about that service, whether they have a basis to or not. So maybe avoiding complaints is a very high aspiration, but certainly there are steps we can take to minimise them. And the first thing I wanted to talk about was terms of business. I know some people call them letters of engagement or terms of engagement, but basically we're talking about the same thing. So the letter or the details that are issued when we take on the business. Sorry, I've gone a little bit too far there. You'll know that there are rules about the terms of business and what should be in them. And the Law Society provide that we have to set out the work that we're going to be doing and make that clear. We also have to say who is going to be doing the work. We have to explain the basis on which fees will be charged. We also have to comment on legal advice and assistance and legal aid if applicable. And finally, we are obliged to explain how the client goes about complaining. So that comes back to the accessible point in our process. The terms of business should set out who the client relations manager is, and also what happens in the event that that person isn't able to resolve the matter for the client. So terms of business I've seen referred to as one of the biggest or best tools we can use to avoid complaints. And I think that that's a good way to think of it, because your terms of business essentially set out the basis on which you're going to deal with the client. And if those terms are effective and they set things out clearly for the client, then it's often a case of referring back to the terms of business to say, well, as set out in the terms of business, I explained, how often I would be in contact with you. I explained how your fee would be calculated. And it doesn't mean you won't have complaints. It doesn't necessarily prevent the complaint, but it minimises the chance of the complaint being found to be upheld, where you have been able to say, no, we set out clearly how this was going to be done at the outset, and that's what has happened, in fact. The Commission did a lot of work recently in reviewing terms of business on an informal basis, and provided a report on what they'd found in terms of business, what they thought was good practice, and also areas for improvement. And it has too much detail to go into at the moment, but I will provide the link for that, because it provides some quite helpful indications of what they certainly are looking for when they're looking for effective terms of business, and even just down to basic things like the length of the terms of business. Are they in user-friendly language? Thinking about your client base, are the terms of business too legalistic, too technical, which would give rise to criticism, or are they clearly written in straightforward terms? Have you thought about things like an alternative set of terms of business for people whose first language isn't English, for example? Do you have different terms of business for different types of work, so that they're bespoke for a particular type of work as opposed to one size fits all? And these are the sort of things that have been picked up in the report. So it does make for interesting reading and provide some quite good tips on the type of wording you could use. I felt particularly around feeing arrangements. There was a large section on that and the different type of wording which would be considered good practice and wording which might be considered to be lacking. So we'll provide the link to that for people to review as well. The next area, which I think helps with minimising complaints, is client management. And really, it's about managing expectations. I've certainly seen over my time in my career, that the profession have clients now who are, quite ready to say if they're not happy about things, and maybe that's the way it should be. However, I think a lot of the time it's about the mismatch of expectations. So we're used to dealing with litigation. In the case of my colleagues, personal injury claims, it might be buying and selling houses, it might be executories. We know how long these things take, we know the steps involved, but often for the client, it's the first time they've ever been involved in something like this, and they've no idea what to expect. And so that mismatch of expectations can lead to dissatisfaction and clients feeling frustrated and feeling that things aren't being dealt with appropriately, when in fact they're being dealt with very appropriately and very effectively, but the client doesn't appreciate that. And so I think that management of expectations and the keeping the communication channels open to be able to be available to explain to the client why something is taking a certain period of time, or why things aren't moving as quickly as they think they may do, can really help in trying to avoid the frustration that sometimes clients will feel, which will manifest itself in a complaint. It might not avoid a complaint, but what it will do, if you've set these things out clearly and you've got records of having discussed things with clients, better still a letter setting these things out and explaining, in our experience, the executive process can take up to a year, for example. You can then point back to that and say, well, I did explain that to you. I did make clear that that's our experience. It may be less than that, but it may be more, but we will engage with you and let you know what's happening. I think that does, without a doubt, help to manage clients' expectations. And that then comes back to effective communication. I've certainly seen instances where solicitors have been doing a first-class job for the client, absolutely excellent work, but they haven't been telling the client what they've been doing. So they've been so busy doing all these great, taking these fantastic steps and getting an excellent result, but the client is in the dark as to what's happening. And that's just a simple, lack of effective communication, but can lead to clients saying that they're unhappy with what's happening when in fact they're getting, an excellent service. And then finally, just to touch upon effective systems. We'll all have our own systems for things, whether they're electronic or more traditional, but having effective systems for diarising dates, for reviewing files, etc., is essential if we're going to minimise the prospect of complaints. Even down to things like delay, it might well be that you just need to have a diary system where you say, write to Mrs. So-and-so just to say the process is still ongoing, and we'll let you know when we hear something further. That system of diary reminders may make the difference from a situation where the client's saying, I don't know what's going on and it's taking far too long. A good idea is to have regular file reviews if you can fit that in. And also I've seen situations with peer reviews, so having a colleague look at a file, maybe one that you're really struggling with and you just can't see a way through, a fresh set of eyes can really help. We certainly have a system where all of our junior solicitors have a named supervisor and regular one-to-one meetings with them to talk about files. So there's an open opportunity to find out about progress, to ask questions, etc. And that sort of system means that the prospect of cases falling through the cracks is minimised, hopefully. So that brings me to the end of the session. With a bit of a rapid run through, but I hope there was something in there that you found useful. If nothing else, you get your Irish Risk Management CPD, as I said. So hopefully that's a result in itself. But I'm going to pass back to Rosie now to find out if there's any questions or anything that anyone wants us to look at.
Yeah, well, again, thank you very much, Catherine. That was all very informative, and nothing like learning on the spot when it comes to doing our poll questions.
Absolutely.
So, yeah. This is our time for our Q&A session right now. So if you do have any questions, please pop them into the chat box. My colleague Neve has been looking over that right now, and I do believe I have a couple of questions. So Neve, I will let you take over from myself, and yeah.
Thank you, Rosie. So yeah, we've had a couple of questions come through, Catherine. One question we've had come through is, do you have one overriding tip for dealing with complaints effectively?
Oh, that's a good question. I haven't actually mentioned it today, and that's not like me, because I always bang the drum for file notes, and I sometimes feel it's really patronising to speak to my peers and say, remember to keep file notes. But if I could give one tip overall, I would say document discussions that you've had with the client and taking instructions. Often we used to get files when we dealt with the negligence claims where, you know, the solicitor would be saying, I did tell the client X, and the client would be saying, no, I was not told that, and had I been told that, I wouldn't have proceeded, you know, something along those lines. And, you know, you absolutely believed the solicitor's telling you that, and you've got no reason to disbelieve them. But the trouble was there was nothing recorded. You would have loved to have found that file note saying conversation with client X, you know, confirmed this information. And, you know, but on the flip side, an effective file note has also brought many complaints to an end, because it allows the client relations manager to look at it and say, no, I can see quite clearly that my colleague has spoken to you on 4 or 5 occasions. This is what was discussed, and so I'm not prepared to uphold your complaint. So I would certainly say file notes. I'm a big fan, and they're a pest when you're busy, you know, and you've just had the 20-minute conversation. You don't want to necessarily have to record the contents of it, but if you can do so and do so as quickly as possible, that would be my one tip.
Absolutely. Thank you, Catherine. I think we've got time for a couple more questions if anyone wants to put anything back into the chat box. But another one we've received, Catherine, is what steps can you take to ensure that clients feel heard and validated when they bring forward a complaint? And there's a second part to this. Is there a different approach to take when the complaint response is visible online as compared to when it's being handled over email or over the phone?
Yes, well, again, there's some quite good guidance out there. I think it's about not being defensive, and it's very difficult, I think, if it's personal, but that's why it's useful to have a client relations manager, somebody who can be a step away. So, you know, trying not to think about, right, who's right and who's wrong in this situation, but actually thinking, right, how can we resolve it? What's the way we resolve it? You know, what is the nature of the complaint? And I think that's really important. So is it a complaint about lack of communication or delay, or is it something that, you know, we can't fix? Is the client saying, you know, I wanted compensation for, you know, my loss of income, and you say, but you didn't have loss of income, we couldn't prove that, so we couldn't claim it. That's not something we can fix for you. So I think it is about getting to the bottom of the complaint, but letting the person feel heard. So, acknowledging that making a complaint is a frustrating process, it's inconvenient. You're sorry that they've felt. I mean, we will often say, I'm sorry you felt that you had to complain, which is quite different from saying, I'm sorry that that you've got a complaint. I'm sorry you felt that you have to complain. So, using a bit of empathy and saying, I understand you feel frustrated, but that's not the same as saying, I think you're legitimate in feeling that way. But just so I think empathy, being open to what's being said, which is not, as I say, the same as saying, yeah, no, you're absolutely right. And you may ultimately say that I think your complaint is groundless, but at least you've been respectful and the complaint's been heard. I think it's difficult online because people will, well, I know that you will know, people will rant online about things. And what I don't really like seeing often is this sort of, engaging in a tit for tat with them, which is so tempting, isn't it, to say, well, no, that's not right and this is not right. But I think, again, acknowledging, sorry that you feel that way, but then saying, if that's the case, I'm satisfied we've given you, a really good service. However, I'm sorry that you feel that you have to complain, but not engaging in a kind of he said, she said, which I just, it's not particularly dignified and it doesn't really get anybody anywhere.
Absolutely. And that was a great answer, Catherine. Thank you. I think we've got time for one more. So our last question that we've got through, sorry, Rosie, I can see you've popped in. Advice for dealing with third-party complaints in executory estates where you are executor and law agent.
Yeah, so that I know that third-party complaints arise quite a lot, and it'll be perhaps beneficiaries. So it's not your client who's complaining, but it's somebody. And I think a lot of people don't necessarily pick that up on. The third party has to be somebody who claims to have been affected by the service that you've given to. So in this case, the service you're giving to the executors, and maybe the beneficiaries are complaining about it. I mean, I think it's still worth engaging to the point of, like we were talking about, acknowledging the complaint, acknowledging that the person's, obviously feels sufficiently strongly to have made the complaint. But there is a limit to the information that you can share because of client confidentiality. And that's something I would say it's perfectly legitimate, in fact, appropriate to point out to the third party that, unfortunately, we have rules about confidentiality and, privilege, which do restrict the amount of information that we can share. And, that can be waived, as we were talking about before, by the client. But, making it clear that this is not being obstructive, this is actually, the legal obligations that we're bound by. And, engaging with the client to say what, that we've had this complaint, this is how I'm proposing to deal with it. And, so that the client, if you like, is on board with that as well. But at the end of the day, when it comes to, if it came to matters going to the Commission, for example, there is no obligation to provide your file, and that's something that the Court of Session made clear. Now, that's not to say you might not want to do it on a voluntary basis to clear things up, having got client permission to do so, but there is no obligation to. But I would still be of the view that, the way to hopefully nip the thing in the bud is to engage to a certain extent in as much as you can without breaching confidentiality and privilege.
Thank you, Catherine. Thank you very much for answering those for us today. I'm going to pass you over to Rosie now, who will bring today's session to a close.
Yes, thank you both very much there. Just before we wrap up, a little bit from me before I pass back to Catherine for some final words. As I mentioned previously, this webinar has been recorded and we will be looking to send that out across the next week. So keep that in mind. Catherine has also said that she will share with us some useful links. So again, that email will be coming into your mailbox across the next week. If you do have any questions that you couldn't think of now, but you think about them afterwards or at the weekend or whenever, please get in touch at the email list you'll see on the screen below you at recover@digbybrown.co.uk. This is the same if you have any questions for your Recover membership at all. We will be running our November webinar at the end of next month, so look out for more information on that to come. That is everything from me. So again, thank you and have a good weekend when it comes. But Catherine, back to you.
Thank you, Rosie. Thank you to Niamh and Rosie for helping me today, and thank you all for being guinea pigs for my polls, which eventually worked. Yeah, no, again, thank you for attending. I'm happy to share the links, and something I forgot to say, which I will slip in at the end, is we've just found this out recently. The Scottish Legal Complaints Commission has actually changed its address recently, so we've had to change our terms of business to give their up-to-date address. So I'll pop that in the email that gets circulated as well. But I hope you found the session useful, you got something out of it, and thanks again for your time.